The Trump administration has lost some significant cases in recent days regarding freedom of the press. In one, a judge permanently enjoined the enforcement of Trump's executive order defunding PBS and NPR. And in another case, a judge ordered that the Pentagon restore press passes for the New York Times, saying that the policy they issued in October severely restricting independent reporting, including reporting from anonymous sources, was unconstitutional. In both cases, the lead lawyer was Ted Boutros, and he's here today to talk to us about how he got those wins, what we can expect, because in one case, it seems, of course, that the Trump administration and the Pentagon specifically doesn't seem to want to comply with the judge's order. Thank you, Ted, so much for joining us today.
Oh, it's great to be with you. Thanks for inviting me.
Now, let's jump into the Pentagon case first, because as you said in the hearing where you filed a motion to compel, we are in the middle of a war. And the Pentagon specifically issued this policy back in October, but is extremely relevant today. Their restrictive policy, instead of complying with the judge's order and allowing the New York Times to have their press passes based on the prior administration's policy, they made it more restrictive. Instead, they now took away the correspondence corridor and said that the New York Times and other reporters had to be in an annex building and escorted in. And also, again, still, they may have changed the language, saying instead of soliciting, they couldn't compel or induce the giving of anonymous sources. But tell us about how in this moment in particular, in the middle of a war, and after a judge's order saying that was unconstitutional, the Pentagon not listening.
It really is outrageous, Dina, that on March 20, the judge issued this really powerful order striking down the offensive provisions in the policy, and talked about how important, especially in a time of war, it is for the American people to have reporters in the Pentagon who know the defense policy issues, who know the department officials, who can get information to the American people so they can decide what they think of going to war and protest it or support it and really serve as a check on the government. And instead of complying with the judge's order, which required immediate access for the New York Times reporters, and we believe all reporters back to the way it was before for decades, the government is just flouting the judge's order. They, as you noted, they shut down the correspondence corridor. I saw a photo they literally ripped down the sign. And that's how they responded to an order from an Article 3 judge. And reporters now have to have an escort even to get into the Pentagon. And so they did the opposite of what the judge ordered them to do. It's just direct contemptuous behavior. So we had a hearing on Monday on this very issue. And again, of all the times to do this, we have the war in Iran, we have the bombings in Venezuela and, the Maduro issues. It's just mind-boggling, and they're really keeping the truth from the American people for no reason other than, I guess, to protect themselves from scrutiny.
Now, you are an esteemed First Amendment lawyer. You actually also, in the first administration, represented CNN and Jim Acosta, when at that time, Trump was unhappy with Jim Acosta's questioning and revoked his press passes. You went into court, got it restored. They ended up then restoring his passes. Just for a moment, let's take a snapshot of this, because obviously this was their attempt in the first term to try to limit freedom of the press and what gets reported. You fast forward to this term, and those two cases right now that you have been involved with, the NPR and the Pentagon, this to me, and I think all of us following along on this channel, sees like a 10x danger. I mean, it has gotten so much worse. Speak to the fact of defunding public independent reporting and also making it so how critical it is that the press cannot use anonymous sources in this Pentagon case.
It's incredible. And you are so right. The contrast, it was tough in the first Trump administration when they took Jim Acosta's press pass. They did try to get around the judge's order for like a day there. And then they said, no, you got your press pass back. That's it. They didn't try to avoid or evade or flout the judge's order. Now, fast forward to today, they're just, just we don't care about the judge's order. They act like they do, but as I argued in the hearing, it's really just a bad faith rearranging of the words. And as you just alluded to, the new policy says that if there's a reporter reports a story and doesn't name his or her sources, promises anonymity, has someone talk on background, that creates a presumption that the reporter has sought classified or unclassified information that the reporter knew was not authorized to be disclosed. So it invades the source-reporter relationship, and it's just over the top First Amendment violating behavior in response to an order. So I think the big difference too, we've seen it in many, many other areas where not only are they enacting and implementing policies that fly in the face of the First Amendment, they're then violating court orders and not respecting the judiciary, trashing judges. So it's really an assault on the rule of law that goes beyond these cases that I think we all need to fight back on.
And you've represented the New York Times, and the New York Times is no stranger to the Pentagon, famously printing the Pentagon Papers and going all the way to the Supreme Court and winning, of course, in court there, being allowed it. And here, despite that constitutional precedent, here they are trying to do something as basic as even printing anonymous sources, which we have done for decades, because otherwise you do have state-run media if you only print the official or, frankly, what that perspective is of any administration. Do you think this is going to end up at the Supreme Court?
It shouldn't, because the principles that the judge applied are so clear. But we are going to fight this. The Pentagon Papers case is a great example. Even after that, the Defense Department didn't pull press credentials, right? They were not happy with what happened. The Defense Department, the government, they let reporters keep reporting because up until now, government institutions, the president, heads of agencies appreciated that reporters are good for them too. They can get the truth out, and people trust it more if they know that there has been this interaction. And so it is really, really deeply troubling. And we're going to keep fighting this, and you can't let this stand. If you give them an inch, they'll take a mile. Other agencies, other departments, the White House might try it, and they cut off the AP for not calling the Gulf of Mexico the Gulf of America. I mean, talk about viewpoint discrimination. So it really is important to fight these battles.
I mean, unprecedented, really, attack and restrictions on the press, truly unprecedented. And you said, in that hearing, or in your brief, or both, that they could have just appealed the order, right? That's what happens. We don't always win. You appeal. But instead of doing that, they created this interim policy that even the judge was saying this is weird and perhaps, worse. But, the Washington Post, at some point, this percentage may have increased, had said that the Trump administration has flouted about a third of the orders. This is their new judicial strategy, you could say, is not appeal, but flout it. And I get a lot of responses of people saying, yeah, but they're just going to ignore the order. They're just going to ignore the order. You're in this situation. And some judges may not be willing to do that confrontation of compel, because then what if, the Pentagon doesn't comply? And then where are we in this? How do you, as you are the strategist, the lead lawyer on this, you are in this moment, how do you handle those considerations?
I felt it was really important to call them out on it, and I did at the hearing. I just said that we've seen this movie before. They're gaslighting the court. They are pretending like they're adhering to the court's order and doing the opposite. And we can't, as a society, as a democracy, let that stand. So I think it's just really important to fight back. I think judges are, that they are not going to tolerate it. So I think we are going to keep having these confrontations. And even the Supreme Court, you saw President Trump a couple of days ago called for Congress to pass a law to criminalize judicial behavior and judicial actions that the administration may not approve of, and put judges in jail for their rulings. We can't tolerate that. That's why I think it's so important, and I'm so honored to represent the New York Times in standing up and fighting back. And so, part of this is part of victory is being in the battle and not letting governmental action that violates the First Amendment, that violates the rule of law, stand. And so I think you see it from other parties, other civil rights groups, fighting back. So we all just need to keep seeking to enforce the First Amendment, the rule of law. Can't let them get away with flouting the law.
Mm-hmm. And you did have a significant victory with the NPR and PBS executive order. Really, his attempt by executive order to defund this public news, you just won that just a day ago.
It feels good. It was really, really important there too, because again, it was just blatant viewpoint discrimination, just like we had in the Pentagon case, where it used to, in the old days, government officials would try to hide the fact that they were punishing you because they didn't like what you reported or what you said. These days, the Trump administration, they're just saying it explicitly. And in the NPR case, the executive order itself said, your NPR and PBS are biased. We want to stop them. No federal funding. And so Judge Moss issued a very strong decision that said, the president can't do this. The government can't do this. It cannot punish speech it doesn't like, either through defunding or other means. So just if you take that with Judge Friedman's decision in the Defense Department case, really two really great judges, really straight down the line, applying First Amendment principles that are so important, not just to journalists, but to the public, who really, the journalists are there as surrogates for the public to get them the information they need. So I think it's been a really good week or two for the First Amendment, and we just need to keep fighting to enforce those principles.
Well, and I just want to speak to the ability or willingness for you to take these cases in this climate, because we have seen Trump go after businesses, people, press that he's unhappy with. And you're at the law firm, Gibson, Dunn & Crutcher, that I'm happy to have worked at. It is not a nonprofit advocacy group. It represents Fortune 500 companies, high stakes, bet the company type cases. The willingness by you and the firm to pursue these very important cases is no small feat right now.
I'm very proud of my firm and proud to be part of it. And it's just important for lawyers. We're baked in, like journalists, baked into the constitutional structure and need to be there to stand up and fight for the system. And it's nothing personal, with respect to Donald Trump or anybody in the administration. That's how the system works, where the government does things that violate constitutional rights. Lawyers represent parties, and you can't be intimidated or afraid to do your job and to fight for your clients. And so I'm so glad to be in these cases. And I have other cases where the Justice Department has been on my side recently. Mm-hmm. So as lawyers, you can't just sit back and let people's constitutional rights be violated. And I'm very glad to be in these battles, because I think it's just really important as for lawyers, for judges, for the rule of law.
Mm-hmm. When I was at Gibson, there was the two Teds, you and Ted Olson, another legendary attorney, and the two of you had teamed up about the Prop 8 case that California, some people may not even know, had passed a law to prohibit same-sex marriage. And the both of you teamed up despite the fact that he was a well-known conservative attorney, to your point, teaming up and winning successfully in the suit. So you have been an advocate in high-profile situations or cases for many, many years. So thank you so much for your legal work. As you said, the acknowledgement that as lawyers, we serve the purpose of standing up for the rule of law above all else. So thank you, though, because right now, obviously people who are tuning in care about free speech, free press, and are very worried about what's happening. And we need lawyers like you who can win against Trump right now or against these bad policies, regardless of what department they're coming out of.
Well, thank you so much. And, I'm so glad to have you as an alumni of the firm, and great to be with you to talk about these issues. It's a really important time in history. And as lawyers, we can do things to try to make things better. And so I'm just very gratified to be able to be handling these cases.
Well, thank you. We'll definitely be following your motion to compel and your other cases, and welcome you back anytime to hear about these very important developments, as you said, in a time of war.
Fantastic. Thanks again for having me.
Thank you.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.